Hello, everyone. We will be starting in just one moment. Thank you. Hi, everyone. I'm Victor Flatt. I am the faculty co-director of the Environment, Energy, and Natural Resources Center at the University of Houston Law Center. And I'm very excited to welcome you all again to the final entry into our 2020-2021 series on energy transition law and governance. This series has been headed by our fellow from University de Lyon 3, Aubin, Remy, Frederick Nzaou. I'm now going to turn the program over to him to just introduce the project itself. Thank you.
Hi, everyone. I'm going to say a few words about the program, as Professor Flatt just said. Our program is funded by the European Commission through the H2020 program and the Marie Curie actions. And our research covers a wide variety of topics on energy, law, and climate governance. So as part of this program, in September, Professor Will Burns from the American University will speak about geoengineering the climate. For more information, please visit our website, www.law.uh.edu/EENR From now on, I'm going to turn it over to Professor Flatt again, co-director of the Center of Environment, Energy, and Natural Resources at the University of Houston Law Center.
Thank you. We're again very excited to have been participants in this program and the grant and the funding. We're very excited about it. We will be, before Professor Benjamin begins, Professor Nzaou will also show you the CLE screen for those who are getting Texas CLE credits. He'll show you that briefly so you can scan it over to Dr. Benjamin. Thank you, Dr. Benjamin.
Thank you so much. I'd like to thank the Center for the Environment, Energy, and Natural Resources and Aubin and Victor. Thank you so much for the invitation. This is a great webinar series. I've actually been watching them. So I'm so pleased to be invited to share this with you. So thank you very much for the invitation. I'm going to share some slides and I'll probably speak for about 35, maybe 40 minutes. And as Victor has said, I am really focusing on a couple of recent, like very recent developments in corporate climate liability. And so what I'm going to do is do sort of a little bit of a retrospective look back in time as to what corporations and investors and directors used to think about the liabilities in quotation marks of corporations for climate change. And then I'm going to look at some very, very recent developments, like in the past year, couple of months, couple of weeks, a lot has changed. Very recently around climate litigation corporations. I'm going to focus on the US and actually primarily Europe and the UK at this point, because there have been some exciting developments through the courts in those jurisdictions. And then finally, I want to finish just by talking about, well, you know, we've had all of these developments. What does this actually mean? What does it mean for corporations? What does it mean for the public? Does it mean anything? So I'll spend a few minutes on that, and I'm happy to, of course, take questions afterwards. So just to start, why am I looking at the US and also the UK and the EU? Part of that reason that I take an international approach to corporate climate liabilities, because corporations themselves, particularly the carbon majors, which I'm going to focus on in this talk, are international. So they're multinational enterprises. They have footprints all over the world. This is a very old caricature of Standard Oil, which was sort of the mother cartel, which was broken up into a lot of the carbon majors that we know of today. And so they have been around for a very long time. These are old corporations. They've been in the same business for a very long time, and they operate all over the world. So they have parent companies and subsidiary companies located both in what I call the global north, and also in the global south where a lot of the extraction and processing takes place. And so because they're multinationals, they are sensitive to developments around the world. And so if there is a case, let's say, for example, in the Netherlands, Shell has to be very aware of that and concerned about it. And so do any other carbon majors that have a footprint in that jurisdiction. So what we see a little bit is some jurisdictions moving ahead of others in terms of imposing liability, very, very recently on these corporations. And that really doesn't accord with how we traditionally understood the role of multinational corporations. So in international law, we think of states as sort of the parties to treaties. They're the ones who have sort of hard law obligations under international law, which I'll talk about a little bit. They're the ones that actually have to implement international treaties like the Paris Agreement, like the United Nations Framework Convention on Climate Change. And non-state actors or corporations have never traditionally been understood as having any obligations, particularly in the international law realm. So I want to take a thematic approach to this talk, and I want to think about corporations in terms of their what we call licenses to operate. So in some of the literature, there have been discussions about what we normally think about as the regulatory license to operate. Corporations need to get permits, they need approval from governments where they operate, they need to make sure that they're complying with laws in different jurisdictions. And so that's what we traditionally think about as the regulatory license to operate, and corporations pay attention to that. Sort of informally, but much more powerful, is the economic license to operate. And so directors are very concerned about profits to their shareholders. And so that has become a very powerful normative influence, and in some jurisdictions under corporate law, legal requirement of directors to ensure that they are acting in the best interest of their shareholders. And then there's sort of this idea of the social license to operate. And this is a much more nebulous term, but it's actually become much more important in recent years than it had been before. So I'm going to look at these developments through the lens of these three approaches that we usually think of what companies care of and what they have to pay attention to. And so the traditional perspective, I'm starting from the 1970s, 1980s, I'm not going back in time. The traditional perspective is that the social license to operate, or the social responsibility of corporations, is to make profits. And this really came from Milton Friedman, this very famous article he wrote in the New York Times magazine in 1970, basically saying shareholders want to make as much money as possible, and directors of corporations should pay attention to that. Of course, you have to pay attention to the regulatory license to operate, but really we're mostly concerned with the economic license to operate. And so the only social responsibility of directors when they're managing companies is to use their resources to make as much money as possible for shareholders. And this has often been known as the shareholder wealth maximization principle. It is very strong, particularly in legislation in Anglo-American jurisdictions, so the US, the United Kingdom, less so in Europe and other countries around the world, but it has a very strong normative influence, even if it's not written directly into the regulations that manage corporations. I do want to say, though, even though I'm starting here as a traditional perspective, this has never been an uncontested norm. There's always been theories and norms that have pushed back against this. And in fact, if you look much further back in the history of corporations, they were much more designed to be sort of public in terms of making sure that they were contributing to society. So, but this sort of doctrine of shareholder wealth maximization really gained traction in the 70s and the 80s and has become extremely powerful and influential. And so this, if we think about the thematic approach, it means that the social license to operate is really not a consideration. It's a bit dramatic, but basically the regulatory license really was to serve the economic license. And so that approach to wealth maximization has been particularly strong in some jurisdictions. And those Anglo-American jurisdictions are where carbon majors are often headquartered or have their parent company. And so those approaches to corporate profits are very influential and have been for some time. So I'm going to go through a little bit quickly some of the developments that have sort of influenced and changed in the past sort of 10 to 20 years and sort of pushed us forward to the point where I think we're at now, that this approach to the corporation is much more contested now, particularly in the context of climate change. So in the 1980s, it's not that corporations didn't care about what the public thought about them, and particularly in the environmental arena. This is a picture from some of the flaring and oil spills in Nigeria, and of course Shell, which I use as an example in this presentation because it's subject to a very new lawsuit, has been very sensitive to, reputationally at least, some of the impacts of its operations around the world, particularly in the global south. And so the Ogoni people in Nigeria have been fighting for a long time through the courts, but also through the press in relation to Shell's operations. Shell's not the only example of a carbon major company that's been subject to this. We can think of the Exxon Valdez spill. We can think about BP and the Deepwater Horizon spill. So this happens all the time. And so social criticism of carbon majors and also other companies in the 1980s, we can think about Nike as an example, have been subject to litigation around this, particularly through human rights. And so there has always been pressure from the social license to operate about the particularly environmental damages and social and labor human rights violations that some of these companies have been accused of. And so they have today are still sensitive to this criticism, and the way that they reacted predominantly is through corporate social responsibility. And so corporate social responsibility has been the main mechanism that many of these companies have used to push back against this social criticism. And so we can see an example of a sustainability report from Shell in 2005. Companies, particularly carbon majors, started to produce these sustainability reports. They would call them different things. And this was their way to sort of manage the social license to operate and the criticisms of it. But they really never had this impact their economic or regulatory license to operate. Sustainability reports are often voluntarily produced. They are not part of financial filings. They will often have sort of very vague and boilerplate statements about how climate change is a problem. Often they will say that it is a social problem if you look back into the history of some of these reports, and therefore it's a problem that sort of the public at large and legislators have to fix. And so taking the traditional, what we all understood as the approach of non-state actors not being subject to international law, it's only if regulators chose to actually regulate them would they have any obligations around this. And so this has been the way that companies have operated for some time. They have also taken much more active approaches to climate change in particular. And so this is a logo of the Global Climate Coalition, which disbanded. This was had the membership of a number of carbon major corporations that they lobbied against any regulation around climate change and reduction of emissions. In addition, there has been some investigation about deception and public deception orchestrated by some carbon major companies. And so this is a logo from the IUCN, so the International Union of Concerned Citizens of Scientists, not IUCN, and they basically have done some research about how some of these fossil fuel companies knew about the risks of climate change and attempted to put news stories in the media to deceive the public. And to a large extent, these were successful. So there is a lot of uncertainty about the impacts of climate change. Climate science is very complicated. It relies on models. It's really hard to predict the severity of impacts. And so these both lobbying efforts and also efforts to sow public deception were fairly successful in the 1980s. And so combined with corporate social responsibility in the 80s and the 90s, the 2000s, 2010s, this went on for a while. This has been the traditional approach of carbon majors. So not all carbon majors have participated in these groups. Not all of them are subject to some of these investigations, but some of them have been. And so this has been the traditional approach. And by and large, it worked to protect the economic license to operate. And so it really delayed, to a large extent, regulatory action around climate change. And some authors have argued even investors themselves have been sort of confused about whether climate risks are long-term, are they short-term, are they medium-term? And so it's been a long, decades-long campaign. And internationally, there has been some action around human rights. And so we can see now this convergence, which I'll talk about, between climate liability and human rights, which has recently emerged. So the OECD has worked for a long time to provide guidelines to multinational enterprises, including carbon majors. They added the environmental chapter to this some time ago. And so multinational enterprises are subject to these guidelines. They are sort of enforced, in quotation marks, through national contact points located in different countries. And these national contact points are the way for members of the public to actually submit complaints around actions of a particular multinational enterprise, and then you sort of enter into sort of negotiations and settlements. The UN Guiding Principles for Business and Human Rights was a long project, and that imposes responsibilities on corporations in relation to human rights violations. But really, these documents were underutilized by the public. They are considered to be soft law documents. We haven't seen a lot of action until very recently around these kinds of responsibilities for corporations through the courts. And so these documents have been around for a long time, but there hasn't been really a lot of legal sort of action underneath them. But we are now seeing that change pretty dramatically in the past, basically, couple of months. So that's a traditional perspective. The UN has also been involved. Of course, the United Nations and members are countries. That's a primary entity that develops and negotiates these treaties. And non-state actors have always been understood to be an important part of the process, but not a member of the actual treaty. So although in the Paris negotiations, corporations and some states wanted them to actually sign on to the treaty, that did not happen. So instead, non-state actors have this sort of compact with the UN, and these have 10 principles. You can sort of voluntarily as a corporation sign up to as any of the principles, and then you sort of post your report online. And when I looked at the compact a few years ago, I haven't looked at it recently, but basically what a lot of companies would do is just post their sustainability reports. And so they would say, we've produced these voluntary reports. This is what, Shell or BP or whatever company it is are doing in relation to climate change. And they sort of post it on the UN Global Compact website. And that's really it. And so that's how they would really sort of comply with some of the principles under the compact. So what changed? In the past, I would say 6 or 7 years, there have been this confluence of events, including the conclusion of the Paris Agreement. But one of the first ones pre-Paris Agreement was a paper produced by Richard Heady, and it's called the Carbon Majors. If you haven't heard of it, have a look. He has a website. And basically what he did was look at 90 carbon major companies and look at their historic emissions. So this includes oil and gas companies, but also cement producers. And if I can just highlight, I'm not sure if you can see my mouse, RWE is one of them that covers both investor-owned companies and also state-owned oil and gas companies. And what he found was looking at these historical emissions that non-state actors, these carbon major companies, were responsible for the majority of historic emissions, actually more than states. In addition, the Paris Agreement was agreed after a very long process in December 2015. And right before the Paris Agreement was agreed, there was a speech by the then governor of the Bank of England, Mark Carney. And he made the speech prior to the Paris Agreement. He actually gave a talk at the Paris Agreement negotiations. And he spoke to insurers before the Paris Agreement was agreed and said, look, we have to be concerned about what he called the tragedy of the commons in relation to climate risk. We have this potential climate bubble. We are focusing in the traditional sort of approach, focusing on the economic license, on very short-term profits, but we are missing these longer-term risks that have the potential to cause serious damage to our investments. And so, of course, he targets insurers because insurers are the ones that are the group of investors that you would think would be primarily responsible for some of the damages from weather events, extreme weather events, from climate change. And that speech, I think, was really groundbreaking. Around the same time, the G20, through the Financial Stability Board, established the Task Force on Climate-Related Financial Disclosures. And so, although SASB has been around for some time, the TCFD has done a lot of work, a lot of consultations with large corporations, basically asking them to voluntarily comply with disclosing the risk that climate change is posing to their entities. And investors have become, as a result of this activity by the TCFD, much more informed and aware of the risks of climate change. And then just a couple of years ago, we had a report by the IPCC. The IPCC is the Intergovernmental Panel on Climate Change. Small island states during the Paris negotiations pushed very hard for a request to be submitted to the IPCC to produce a report around the feasibility of 1.5. The reason small island states wanted that was because we wanted a marker in the sand to actually tell the world how close we were to approaching 1.5 and how dangerous that was. The Paris Agreement has global temperature goals to keep increases well below 2 degrees Celsius with an aspirational goal of 1.5. And so the feeling was that people thought, oh, 1.5 is not going to happen, so why are we paying attention to this? And this IPCC report, they have lots of different reports over time, but I think this is one of the most important reports they've ever produced because it woke a lot of people up to the risks and dangers of 1.5. Everyone thought 2 degrees, well below 2 degrees would be fine. But actually the IPCC was very clear that 1.5 is dangerous and very close. A year later, the UN director said that the point of no return of climate change is hurtling towards us. So we have a very small window. And then these people, as in young people, got involved. And this really happened right before 2020. There were these Friday protests, if you remember, of young people who became very concerned about climate change and their future. They became very angry and they talked to their parents about it. And that kind of swelling of social anxiety around climate change, I think, has sort of led us or contributed to the point that we're at now. And so these are the recent developments that I want to look at. I'm going to start with the US, and then I'm going to move on to the UK and Europe. So in the US, there's been not a lot of regulatory activity around climate change, but there's been sort of, as a result, perhaps, of the sluggishness of regulatory action, a lot of litigation suits. These have been dubbed as the second wave of climate litigation. We've had suits, particularly against carbon major corporations, that failed. One of the reasons that the first wave of litigation failed was because of the political questions doctrine. Judges thought that this is best left to the legislatures. This is still a concern in terms of the ability of these suits to be successful. They're brought predominantly against carbon majors by states and cities for the cost of adaptation. Businesses, so some fishermen in Oregon and California, I think, have brought a suit, but it's predominantly by state entities. And there have also been a couple of suits against carbon majors for failure to adapt. So for example, with sea level rise, for leaks in terms of storage. The litigation hasn't gone very far, and there's a lot of wrangling around whether it should stay in state court or in federal court. There's a recent Supreme Court decision around Baltimore, which is one of the ones that's moving forward the most quickly. And basically the Supreme Court sent it back to the Fourth Circuit and said, you know, you sort of did a remand order under a limited doctrine of federal officer removal. You should have done it under broader grounds. But what I think is really important about this case is the Supreme Court said, we're not going to discuss the other removal grounds. And that's basically whether it should stay in state court or federal court. And we've seen that the Supreme Court kind of doesn't want to get involved in these litigation suits. And that's probably a good thing. So it's not really clear where this litigation is going to go. Even if it stays in state court, there are going to be limitations around whether or not you can sue for the emissions of within the state or outside of the state. But actually, I think one of the more exciting developments in the US is not actually around litigation, it's around changing administration. So we all know that the Biden administration is extremely concerned about climate change. It's one of the top priorities. So it's jobs, justice, and climate. And this executive order issued last month is around climate-related financial risk. And so this is a really, I kind of knew it was coming from the news, but I really didn't expect an executive order around climate-related financial risk. It's something that has not really been a top priority for previous administrations, even under the Obama administration. And so there's significant sections in this executive order directing federal agencies to act around financial risk. And this executive order follows on from a previous executive order on climate change, which was issued, I think, in the second or first day of the new administration. This develops what's called the whole of government approach to climate-related financial risk. And it asks key federal agencies, the Treasury Secretary oversees this through the Financial Stability Oversight Council, to really identify and disclose the risks to the federal government and federal agencies, financial risks, and also to financial institutions in the United States. So all of a sudden, we're seeing a lot more activity around the financial risks of climate change in the United States. I think one of the most interesting parts of this executive order is actually around procurement, and I think this could be effective very quickly. And so it asks this Federal Acquisition Regulatory Council to consider amendments to regulations that would require major federal suppliers to the government to disclose the risks of climate change and set science-based reduction targets. So this doesn't just cover public suppliers, it covers private suppliers. And I had a look just last night on Wikipedia, so don't hold me to this, about who is the sort of major suppliers to the federal government. In terms of federal agencies, it's defense as sort of one of the largest procurers, which is, you would think, is normal. And then the Department of Energy is second. And so some of the actual suppliers are some of the military suppliers you would think, like Boeing, but also GE, IBM, Deloitte, FedEx, Rolls-Royce, AT&T, Royal Dutch Shell, BP, and interesting at 96, the Government of Canada. So it's a really broad range of suppliers who would be subject to federal agencies considering disclosure of risks and emissions and whether or not these suppliers have set these reduction targets when making procurement decisions. And so procurement is one of the first ways that governments can actually make significant reductions. So it's a really interesting and implementable part of the executive order. So the SEC is an independent agency, and so it has also been taking action prior to this executive order. And so with the change of administrations, the new acting chair of the SEC, Allison Heron-Lee, in March made a call for comments in a really pretty substantive set of questions around whether and how the SEC should mandate disclosures on climate change. So there's existing guidance by the SEC, but it has not really been enforced. And so enforcement through a task force and the SEC of the existing guidance is happening. But also this question is whether or not the SEC should pass rules and go through rulemaking to require entities that are subject, so big public corporations that are subject to the SEC, to disclose the risk of climate change. So the comment period closed a couple of days ago. Interestingly enough, the Business Roundtable has actually in their comments said, actually, we think that disclosures are okay. And that's a huge statement from the Business Roundtable. Not everyone is happy with it. So there have been at least one letter from some oil and gas companies that said it's not under the mandate of the SEC to do this. So it's not going to be an entirely easy road, but we've seen a lot of changes in the business world around disclosures, a lot more comfort level with disclosures. And part of this is because big investors like BlackRock in 2020 said, we care about climate change, and CEOs were actually going to ask you to care about climate change. And if you don't care about climate change, we're going to do something about it. So for BlackRock after 2020, nothing really happened. So people thought, oh, it's just a statement. But actually BlackRock supported last month Engine Number One, which is an activist hedge fund, who actually successfully was able to submit a proposal accepted by shareholders for at least 2 and I think perhaps 3 directors on the board of ExxonMobil. So what Engine Number One asked basically was improve strategic approach to climate change, including connecting compensation of directors to the risks of climate change, and basically to put more expertise on the board. So even and Chevron went through a similar exercise with a shareholder proposal, which was accepted, so less comprehensive. So even when we don't have regulation, we can actually see that some of these carbon majors are being pushed by their own investors to actually take some action on climate change. And so Engine Number One has a website. I looked at their proposal on long-term shareholder value, and basically sustainable value, what they're asking for is for a longer-term vision around sustainable value. And so that stakeholders are considered as part of the value creation, and also for companies to look at the value that they're creating, but also destroying. So it's a really interesting way, I think, to think about value, not just in terms of shareholders. So in the UK, we've had legislation for a long time on climate change. This establishes an expert committee which advises the government. There hasn't been as much litigation over climate change per se. What there has been a lot of litigation against parent companies for the activities and omissions of their subsidiary companies around the world. And this is actually connected to climate change because a lot of the parent companies that are being sued are carbon major companies. We used to see this principle familiar to corporate lawyers called piercing the veil all around the world, but actually piercing the veil has sort of fallen out of favor in the United Kingdom. And this sort of principle about the fact that parent companies have a duty to be responsible for some of the acts or emissions of their subsidiaries has sort of taken the place of piercing the veil. It's sort of gained in traction over the past few years, and it's been really interestingly extended not just to employees of subsidiaries, but also neighboring communities. And this is really important, particularly in Nigeria and Shell. So this is a very sort of brief timeline. I'm not going to go through all these cases, but basically it started in 2012. We started to get these, what they call the Chandler factors from this, the first case at the Court of Appeal, which established, when would a parent company be responsible for the acts or emissions of their subsidiaries? The normal corporate law doctrine is that a company is a separate legal entity. It has limited liability, and so it's not responsible for the debts of its subsidiaries. And so this really works against that. We can see that there have been some ongoing cases that involve Shell, They also involve other companies like Unilever for labor violations in their tea plantation subsidiary in Kenya. And we've also seen a case, which I'm going to talk about a little bit because it's the most advanced, Vedanta, which is copper mining. So Chandler and Cape was the first time we saw this. This was actually asbestos. There are lots of analogies between asbestos litigation and climate litigation. And this was a factory in the UK where a subsidiary employee was working. The parent company actually rented some premises, and you can see that the walls are open in the factory. Asbestos was produced by the parent company in this factory. The dust went everywhere. The employee of the subsidiary became ill. The subsidiary company was insolvent. The employee of the subsidiary sued the parent company successfully. And so the parent company was held to be responsible for the illness of that employee for four factors. One, if it's the same business, basically. If the parent knew what the subsidiary was doing and that it was unsafe. And then finally, the employees would rely on that. So the first case was just about employees within the subsidiary and didn't extend beyond the actual companies. The next series of cases extended it. And this is where it gets really interesting in the global south, particularly in natural resource extraction. This is a Konkola copper mine in Zambia. The subsidiary neighboring, sort of polluted basically the neighboring land, and villagers in that neighboring land sued. And the high court said, we're going to extend these Chandler factories to this neighboring community. And that was really unexpected. And the Court of Appeals said, yeah, we agree. We think that this duty of a parent company can arise as a result of group policies that the group has. So remember, we talked about Shell, its sustainability reports, how nobody paid attention to these sustainability reports. These reports are often produced by the parent company. And so the fact that groups are producing and parents are producing these group reports because they're basically dictating the operations of the whole group, that could actually, under these series of cases, at least be part of the liability discussion and the duty of the parent companies. And you can see the Vedanta policy actually says one vision, one Vedanta, like it's one group. And the group policy actually says that. And so the Supreme Court accepted jurisdiction for this. It says we can see that there could be a duty of the parent company. We're not going to dictate what kind of corporate models this could be imposed in. We're going to leave it really open. That's what the Supreme Court said when they accepted jurisdictions, and also said that group policies, yeah, we think that that could establish liability or duty, at least for the parent company. Vedanta then went through the process of renationalizing this mine. And so it's unlikely that we're going to get a substantive decision around this. But again, the same things happened with Shell. And so Shell has been sued by the Ogoni people for mismanagement by its subsidiary. Lots of leaks from pipelines. And so the Court of Appeal, the High Court said, no, we're not going to extend these Chandler factors to Shell. The Court of Appeal agreed with the High Court, but there was this dissenting judgment by Lord Justice Sales. And Sales said, actually, we can see there's been significant mismanagement by the subsidiary. The parent company is facing a lot of reputational and financial risk because of this leaking pipeline. And we can see operationally, at least, the parent company knew about this, even though it doesn't hold a permit or a regulatory license in Nigeria to actually refine. And so this decision in the Court of Appeal, it was saying, no, we're not going to extend it. But the dissenting judgment by Lord Justice Sales has been picked up by the Supreme Court. And so the Supreme Court agreed earlier this year to hear the case. And in that sort of procedural decision, you can see that the Supreme Court is picking up on its decision from Vedanta and saying, actually, we think that we could extend it to the parent company. And so it's clear operationally the way that the Shell Group works that they knew about this pipeline. So basically the subsidiary had a direct operating line to the parent company to inform them of these reputational risks. And the Court of Appeal in the Supreme Court's initial view took too narrow of a view of this duty. And so that's, again, a really surprising decision. We'll see if we get a substantive decision by the Supreme Court in the United Kingdom around this. But again, it really pushes back against the traditional principles that we think about in corporate law and regulatory license to operate. So finally, I'm going to look at Europe very briefly. In terms of regulatory licenses, Europe has been, the EU in particular, has been far ahead of the United States in developing a disclosure regime around environmental, social, and governance indicators. It's been working on this through a high-level expert group for several years. In addition, individual countries in the EU have developed their own regulations. So There's this what's called the duty of vigilance in French law. This is new, I think around 2017 it was established. And this tells large corporations, I think who have 5,000 and above employees, that they have to create a vigilance plan. That plan has to be public. It has to disclose the risks that corporate activities are posing to human rights and also to the environment. There are a lot of like disappointing reports that have come out of this duty, but Total has been sued. It's been sued twice, once unsuccessfully. And I think, again, most recently, there has been an acceptance of jurisdiction to hear a case against Total in relation to their failure to disclose climate-related risks. So we'll see where that goes in France. There's been lots of litigation around climate change in the EU. One of the most successful is a case brought by Urgenda against the Dutch state that told the Dutch state that they have to reduce their emissions, partly because climate risks will violate human rights. I think just today, there's been a similar success in Belgium, where the Belgian government has been told to reduce, based on the Urgenda case, to reduce its national emissions. Again, in a couple of years ago, RWE, if you remember from Hedy's report, RWE was sued by a farmer and mountain guide, Mr. Luya, who lives in Peru. This was one of the first cases where a court in Germany said, in principle, this German utility, RWE, could be liable for the cost of adaptation for Mr. Luya to protect his village in Peru. So that really was an unexpected decision. They're moving to the evidentiary stage now. So there's not actually a substantive decision that RWE is liable, but this suit has been going on for a couple of years. And so even that the court is proceeding to the evidentiary stage is pretty remarkable. And then finally, just last month, we had a successful claim against Royal Dutch Shell in the Netherlands. This case is actually our first substantive decision. It will be appealed, but it's a decision under Dutch unlawful endangerment. It relied on Richard Hedy's study, and the court determined that RWE is actually responsible for more emissions as a group than the Dutch state itself. So we knew that from Hedy's study, and the court actually relied on that. And it determined that, Royal Dutch Shell knew about the risks. It knew that its inaction would be a threat to human rights. The decision relies heavily on that IPCC report on 1.5 that I talked about earlier. And it says that because our Royal Dutch Shell is a multinational company, it's got to pay attention to global emission reduction pathways. And that's why the IPCC report is so important. So that multinational character of the group is really important in this decision. It's headquartered in the Netherlands, although its parent company is registered in the United Kingdom, and we know that it's facing legal pressure in the UK already from that duty of parent companies. This Dutch decision relies heavily on the Urgenda decision. Of course, the Netherlands is a civil jurisdiction. International law is directly binding, and so this might not be replicable in common law countries, but it's a really groundbreaking decision. In addition, the court relies on these documents that we always consider to be soft law, and it's really, I think, one of the first times that corporations have been held under these documents to be liable. And so what the court said was that the UN guiding principles in particular impose responsibilities on companies. It does not matter if the state itself is complying with its obligations under these principles. The company must. It has independent obligations under the guiding principles. This obligation is non-avoidable. It applies regardless of where you are operating. It's not passive, the court said. It requires action by businesses. That action should be proportional to the size and the operations of the business. So large companies are going to be more responsible than smaller companies. And it depends on the severity of the impacts to human rights. And we've known for some time that climate risk can constitute violations of human rights. The court says that Shell has a best efforts obligation to reduce its emissions by 45% by 2030. And interestingly enough, this applies not just to its scope 1 or 2 emissions, but to its scope 3 emissions. And scope 3 emissions are the end use of its products by the public. What Shell has and many car managers claim is that, well, that's what the public is doing. We can't control what the public does. They choose to, buy fossil fuels or they don't. But this statement by the court, I think, is really interesting. It talks about the influence and control that the parent company has on emissions by end users of the products sold by Shell. So it basically tells the parent company that you actually have influence that we all knew that they had, but that was very informal influence. And the court says, we know that that is the influence that you have. This best efforts obligation applies to your whole group, not just the parent company, which doesn't actually produce anything. And in relation to the economic license to operate, I thought this quote was fascinating. So, of course, companies will argue that if they reduce, it's going to damage their economic license to operate. And the court says, well, actually, the interests that are served by the reduction of your emissions, basically human rights violations and the significant and serious threats to the human rights of Dutch residents in that particular region, that the severity of those risks and impacts means that Royal Dutch Shell might have to take some drastic measures and make financial sacrifices to limit emissions to prevent dangerous climate change. And so for people who've been studying corporate law for a long time, that does not accord with our traditional understanding of how corporations operate in practice and the theory of corporate law. So this is a really fascinating decision. It's going to be appealed, so it's unclear what the enduring impact of this is. But we can see that there have been many developments around the world. Even prior to this decision, some carbon major companies like BP and Shell have published what they call net zero ambitions. So nobody's really sure what that means. They're not targets, they're ambitions. And so there has been activity by these companies anyway. Things are getting worse, of course, with climate change, which is no surprise to people who work in the area. The World Meteorological Organization issued a statement last week or 2 weeks ago saying that there's a significant percentage chance that we are at least temporarily going to exceed the 1.5 degree threshold. And of course, the odds increase with time as if we don't make drastic reductions. So what does this mean? I don't know is the answer, but I think that things have shifted significantly in the past couple of years. There have been some really, I would say, unexpected legal developments. I think that that means that the economic license is no longer in practice the only license that directors have to pay attention to. They really have to pay attention to the social license to operate. What that means is nebulous, but they can't ignore it or at least just pay sort of lip service to it through issuing sustainability reports. Regulatory licenses are probably going to be affected by some of these changes and movements in liability. The extent to which they're changing will vary with jurisdiction. But I think that we are definitely in the world of mandatory climate risk disclosure. I think even if the SEC does not manage to successfully pass rules or going to enforce the guidelines, it's definitely going to be mandatory in the EU and already is in the United Kingdom. I think the potential for climate liability in Europe has happened already with the Dutch decision. It's definitely happening in relation to state reduction targets. I don't know if it will continue to happen and be upheld against non-state actors, but it's definitely going to lead to increased national targets. And that means that if states have to reduce their targets, they're going to have to require that corporations that operate in their state reduce their targets too. So I think we're going to see evolving targets on non-state actors for reductions. In terms of the economic license, we have seen for many years substantial pressure by investors for corporations to change their strategic approach, particularly carbon major corporations. I think that might motivate some more investment in renewables. It's definitely already motivated transitions to natural gas. Some carbon major companies are trying desperately to lock in infrastructure around natural gas. There will have to be some better methane capture. And for many years, some of these companies have been investing in carbon capture, utilization, and sequestration. So I think we will see that increase as well. The social license to operate has really coalesced around a better understanding of the immediate risks of climate change. These risks are escalating. We're feeling them all over the world, even in global north countries, and the public will become increasingly concerned as the impacts increase. I think that's happening already. So I think for corporations, this traditional corporate social responsibility approach doesn't work as well anymore. I'm not saying that corporations aren't going to still use it. We can already see some suits around greenwashing against carbon major companies that are talking about and their targets. I think these companies are going to have to think about even voluntarily or involuntarily putting more expertise on their boards, or at least a subcommittee of their boards around climate change. They're going to need this to actually evaluate the risk of climate change properly in accordance with disclosure requirements. And they're going to have to do a better job of disclosing climate risks because their investors are demanding it. So of course, some firms are not going to be on board. There will be resistance. There'll be litigation against it. But some businesses are already considering diversifying away from fossil fuels. And I think this sort of concept of a more sustainable and durable value by engine number one is one to pay attention to. So creating sustainable value in the short, medium, and long term, I think, is a consideration for companies, particularly as the risks of climate change pose threats to their profits. So finally, just to end, this is my second to last slide. If you haven't looked at it already, I would highly recommend, if you're interested, looking at the second edition of the Enterprise Obligations. These were published a couple of years ago by a group of legal experts, and I read them when they came out in 2018 or 2019. And I remember reading them thinking, oh, wow, these are really progressive. And they talk about these legal obligations as where the law is heading. And at the time, this was pre these decisions, people thought, oh, there's no climate obligations for enterprises. This is just pie in the sky. And actually, they had to update their edition. So they have a second edition, which came out this year. And actually, some of the obligations that they put in the first edition have already happened while they were updating the second edition. So it just goes to show you how quickly things are moving. The second edition is really interesting because it extends liability beyond what we traditionally think of as the carbon majors. It extends it to large entities like big agriculture. It talks about the obligations of major internet suppliers like the Amazons, of supermarkets, for sort of pushing and marketing overconsumption of fossil fuel-based products and services. It talks about luxury consumption and luxury goods and the idea that those should cost more. It talks about packaging and plastic and obligations around considering that, and obligations for companies to consider their supply chain. And so I think these are really interesting set of obligations. I've actually been surprised by how accurate they have been, particularly the first edition. And so I think they really give us a roadmap to where corporate liability is going. And then just to end, pre-Friedman, we had Schumpeter, which talked about the creative destruction. Capitalism and the creative destruction is a phenomenon and a principle in capitalism, and this can happen to corporations that do not pay attention, I think, to their social license to operate. So that is it. Thank you very much.
Thank you. Thank you so much, Dr. Benjamin. So this is such interesting information. Before we get on to a couple of questions, I also want to introduce my colleague, Professor Tracy Hester, who is an expert in climate change litigation and climate sequestration. And so I'm just going to start out the questions. There's so many I want to ask you. We'll have to have a long conversation about this, but I will just ask one. This is more practical, perhaps, and not quite as sublime as the way you've all put it together. But when you were talking about corporate social responsibility, one of the things that I found of interest in thinking about those statements is my belief that if a company says something in a corporate social responsibility statement, it has to be true, or they have to back it up, because it can be seen by potential investors bringing under the rubric of SEC disclosure obligations. And we now have in the EU the more specific climate disclosure requirements. I think that happened last year or this year. So do you see any, at the sort of lower levels, lower ground corporate law, do you see any potential for people to use this to pressure companies to make better CSR statements or more accurate CSR statements? Are the CSR statements simply going to merge with the climate disclosure statements, or because there's also still other social issues, environmental responsibility? Anyway, just your impression of that.
Yeah, so it's a catch-22, right? So for companies, they make these vague statements. Investors don't like that because it gives them no idea of what the actual concrete risks are to the company. Companies say we make these vague statements because we don't want to be sued for misstatements. And so I think there's a couple of options of where this could go. And some of these are reflected in the comments to the SEC's recent call on proposals for disclosure. So some of them, some companies want to keep these as separate disclosures in relation to climate change and don't want to put them in their financial filings. Some investors definitely want them to be in their financial filings and want them to be more obviously comparable, consistent, accurate. And so if we see them move towards a much more sort of detailed line item disclosure requirement, we are definitely going to see a push for safe harbor from litigation for these kinds of statements. And so that has also been included in some of the comments to the SEC. I think we can see from the French example, the duty of vigilance, that if the statements are incorrect, there is a potential for liability against companies for misstatements, basically. So I think I'm really curious to see which way the SEC goes. I'm working on a paper around that and climate risk. I think there should be more accurate disclosures. And so we'll see if in return the SEC says, okay, you can have safe harbor from these disclosures. So we'll see.
Thank you. I'm now going to turn it over to my co-moderator, Tracy Hester. Tracy.
Hello, and it's a pleasure to be with you. And what a fascinating conversation. I think I may try and waylay you at a future conference and spend an hour just talking about some of the implications of this. I also might also gently add, unless this already got discussed, your PowerPoint presentation was very informative. And if you could share that with our participants, I think we'd really appreciate it. Beyond my questions, I also want to make sure that we field some of the questions coming from the attendees. And one in particular, just to start things off, dovetailed with a question I was hoping to ask you as well. James Mwanda has asked, essentially, and to distill this question down a little bit, the emphasis on US and European legal remedies promises some pretty rigorous standards and possibilities for development, but he's concerned that it essentially creates an opportunity for multinational corporations to shift their operations in a way that allows them to essentially shield themselves from liability. I was also curious whether or not some of the litigation you've been looking at raises prospects of transnational enforcement of foreign judgments. If you get a good judgment, say, for example, in Canada or in an EU court, can you then basically tuck it under your arm and more readily enforce that foreign judgment in another jurisdiction when you might have difficulty bringing your own action under that jurisdiction's own laws?
So extraterritoriality and transboundary liability is super complicated, and I'm not an expert in that. So I will say, first of all, that's not my area. But I will say it's definitely a concern. And so I've been watching this, particularly with the litigation in the UK. We've seen, particularly in that case, the Venanta case in Zambia, there was not, so to be able to actually get a forum in the UK, you have to prove that there's not an appropriate legal jurisdiction or legal redress for you in Zambia. And so they were able to prove that. And there are some, in the earlier discussions of that line of cases, a discussion by the UK courts about how redress and avenues for justice were not available for these claimants in Zambia. And so there is a potential to get this, if there was a judgment in the UK, and then to bring it back, for example, to Zambia to be able to enforce it. That's exactly what they're trying to do with Shell in Nigeria as well, to basically ensure that the parent company becomes responsible for its subsidiary. Of course, the sort of flip side to that could be that Shell says, okay, we're now getting rid of the subsidiary. we're not responsible for it. We're going to change our group policies. We're going to have some kind of like indemnity between the companies. You know, they will try to perhaps have some creative commercial way around that liability. But the fact that this is happening at all, and I have a paper about this, that it provides redress for vulnerable constituents in the global south, I think is really important, because we've had a lot of extraction activity, particularly in countries in the global south, a lot of pollution, and really not a lot of liability or redress for vulnerable, climate vulnerable constituents in the global south. So I think it's a really important development.
Wonderful. We have another great question from an attendee, but I also know our time is starting to grow a little short, so I may resort to the time-honored moderator tactic of packaging two questions and see if you could perhaps provide answers to both at the same time. Miralini Shinde, I hope I haven't terribly mispronounced your name, ask, do you see any similarities between corporations and natural persons that we could see corporate social responsibility as a kind of community service? My parallel question is completely different. By the way, Victor said he might want to answer this one too. My parallel question real quickly is I've seen, perhaps you may have seen recently, Jason Bordoff in Foreign Affairs and other commentators have raised the comment that the emphasis on private corporations using corporate social responsibility and corporate law may have a spillover effect for national oil companies and other sovereign corporations. And I was wondering if you had some thoughts as to whether or not there are legal tools that can help on a parallel track constrain some of their activities, since they're essentially quasi-sovereign, perhaps under public international law.
So on, hi Marilini, it's nice to sort of see you via chat. Yeah, the parallel with individuals, so corporate personhood is the idea, it's a contested idea, but the idea is that corporations have rights. We've seen a lot of rights granted to corporations, but a lot of responsibilities granted to corporations and imposed. And so I think there can be parallels to that. The idea that corporations are fully people has always been a little bit contested. But I think that non-state actors, corporations have always been very concerned with corporate social responsibility from reputational reasons, but also, financially, it can be very helpful for them to do that. And so we've seen a long line of corporate cases very far back saying that charitable contributions by corporations are fine. And so that idea of the economic license to operate has never been sort of unviable in a sense. And I think that we also see very wealthy individuals and billionaires get very involved in climate change. So someone in another webinar said that they go to space or they become very involved in issues on Earth. And so we see a lot of that in that space as well. So I think the idea of corporate personhood is controversial, but I think that the corollary of obligations imposed on corporations really matches the idea of them being granted significant rights under law as well. So the analogy is not perfect, but there can be some analogies. In relation to state-owned oil and gas companies, I discussed at the beginning HEDI's, and I'm really, Victor, I'm really interested in your views of this as well. So HEDI's assessment actually looks at the significant contributions that not just investor-owned, but state-owned oil and gas companies have. And they are tremendous emitters. So they're a really important piece of the puzzle. I almost wrote a paper on that, but I didn't. In the global south in particular, you have Sinopec, you have Saudi Aramco, you have these really large state-owned companies. And so they're in this weird space that these governments have ratified the Paris Agreement. They have obligations as states under the Paris Agreement. So in theory, it should be easier for them to translate those obligations onto state-owned oil and gas companies, but you don't see a lot of that activity happening. And so I think it's an unexplored space, and I think it's a really interesting one to look at. Some of this investor-owned activity, some companies sort of follow, and there's a lot of market pressure. I don't know what will happen with these state-owned oil and gas companies, particularly because they are often located in the global south, and global south countries often say we're following the lead of the developed world. So once you do it, we'll do it. So we'll see what happens. Yeah, but it's a really interesting question.
And we may see a whole rich new second wave of climate litigation focusing on sovereign entities and perhaps maybe international arbitral tools instead of courtrooms. Victor, you'd said you wanted to answer this question live as well and make sure.
No, that's fine. That's fine. It's all set. We are out of time. So I want to thank you, Dr. Benjamin, for a fantastic presentation.